Family Law Project, Child Custody Dispute in Common Law Marriage by Laura Flynn and Katie Boyle. This is Kevin Putnam. Kevin is a 37-year-old who proudly owned and operated a farm with his brother Rick out of Lowell, Indiana. This is Louise Maverick. Louise is a 34-year-old who enjoys a career as an up-and-coming food scientist from Boston, Massachusetts. Kevin and Louise met at the Farm to Table Conference in 2007 in Boston, Massachusetts. This is where their love story began. When Louise got a job offer to be the lead food scientist at a Texas food processing lab, Kevin decided he could not live without her, so he followed her to Texas. There, Louise and Kevin started to build a life together. Their love blossomed, and 8 years later, Louise and Kevin welcomed a baby boy named Pete. Kevin decided to pass his shares of his family farm to Rick so he could stay home with Pete while Louise worked. Shortly after Pete was born, Louise and Kevin noticed that they had significantly different ideas on how best to raise him. This caused severe strain on their relationship. Due to the unbearable bickering with Louise about Pete, Kevin went to see attorneys at Boyle Firm LLC to seek legal advice. When asked by the attorneys what Kevin wanted, he stated he wanted to leave Louise and take Pete back home to Indiana and raise him on the family farm. After doing the necessary legal research, the attorneys at Boyle realized that there were two important hurdles they had to tackle before they advised Kevin. First, is Kevin and Louise's relationship a common law marriage under Texas's proof of informal marriage statute? And second, if so, how custody is handled in common law marriages? The attorneys found a Texas statute that is on point as well as a persuasive case. First, according to Texas FAM Section 2.401 sub A sub 2, a couple is considered to be common law married if the man and woman agree to be married and after the agreement they lived together in this state as husband and wife and represented to others that they were married. The persuasive case the attorneys have at hand is Jennings versus Hurt. While the case is not binding in the present jurisdiction, the attorneys feel it is helpful to Kevin's case. In this case, the plaintiff and defendant met when the defendant was married. The couple lived in South Carolina and the defendant told the plaintiff that they were married in the eyes of God. The court in this case laid out 4 elements to establish a common law marriage. First, each person had to have the capacity to enter a marital agreement. Second, there had to have been a present agreement to be married. Third, the couple lived together, shared a bed and physical intimacy. And fourth, the couple had to have held themselves out to the community as husband and wife. With this knowledge in mind, the attorneys asked Kevin more about his relationship with Louise. Kevin shared 4 stories. First, he recalled a conversation he had with Louise about whether or not either of them had been married previously. They both had never been married and were not currently married at the time of the conversation. Second, after moving to Texas, they did not have enough money to get married, but believed that they were married in the eyes of God. A piece of paper didn't mean anything. Third, he and Louise have shared a home together for the past 10 years. And fourth, Kevin recalled that every year they send out season's greeting cards to family and friends, signing the cards, the Putnams. Based on this information, the attorneys concluded that there was enough evidence to support a finding of common law marriage under both the Texas statute and case law. Therefore, if Kevin decided to leave Louise, he would have to go through divorce proceedings. Because a common law marriage was established, and should divorce ensue, the custody of their son will be decided by the courts through custody proceedings. In Texas, the custody process is referred to as conservatorship. The applicable statute discusses possession and access of the child. Under Texas law, when a minor child is involved in a divorce, the courts will refer to the best interest of the child test under Texas FAM Section 153.002. This section reads, "The best interest of a child shall always be the primary consideration of the court in issues of conservatorship and possession of and access to the child." The attorneys advised Kevin that should he want to move back to Indiana with Pete, the court will take into consideration Pete's best interests, such as who is the primary caregiver between him and Louise, who is financially more stable, Pete's age, and the type of emotional trauma a big cross-state move will have on Pete. Following Kevin's consultation with the attorneys, Kevin had some big decisions to make and a lot of thinking to do. He thought about his family farm in Indiana, his relationship with Louise, Pete growing up, and whether he was okay with Pete growing up with two parents in separate states. Now, Kevin needs some time to think over everything and make a decision.